Okay, this is how to win a felony case against you without a lawyer. I am an award-winning felony crimes defense attorney. You can find my links within the description. Um, Before I go on with these, I'm going to reveal a few secrets as to how this works. Most attorneys don't really like to reveal this stuff because they think that they won't be needed if people know how to do this stuff on their own. I actually disagree tremendously. I think it's important for people to know how the legal system works and how you may even be able to effect a very strong defense on your part. Many times what ends up happening is folks come to our office and they want us to eventually get engaged in the process to help cement the victory. I don't recommend self-representation. I can understand why people want to do it. They don't have any confidence in the court-appointed attorneys. I get it. And it's expensive. To get a really good lawyer costs money because you want that lawyer to have the resources it takes to win. Somebody who charges very little, you're going to get very little out of it. So anyway, moving forward, the first thing you need to know is how the process works in the courts. Now, I can speak only about California cases, California criminal courts, the state you live in, or if you're watching this outside of California, the framework might be similar, but I can't speak to that. I can only speak to California because this is where we practice. The way it works is when you're facing a criminal accusation for a felony crime. Now, generally speaking, before I get into that, a felony is punishable by state prison. It's generally punishable by more than a year in custody. There are some other criteria. You can look those up online. You can go to our website. You can visit other websites that talk about which crimes are felonies. Some crimes are felonies and misdemeanors. They're called wobblers because they wobble or they straddle the fence between a misdemeanor and a felony. You can find that out on your own. But if you are facing a felony case, it's very different than if you're facing a misdemeanor. The penalties are much more severe. There's a lot more at stake. And it's not as straightforward, but I'll help you understand it as easily as I can explain it. The firing shot, so to speak, in the courts is what's called the arraignment. Fancy word, but a very simple concept. The arraignment is the first court appearance. You're there to enter a plea of guilty or not guilty. Very, very few people, or in very few cases, but it does happen. The person, again, this is assuming that they represent themselves, which is becoming a little more common because of the financial limitations. But generally speaking, most people don't go ahead and rush to enter a plea of guilty because at the end of the day, it's the government's burden. They've got to prove your guilt. You are not, a lot of people ask me, well, aren't you, testifying under oath that you did or did not commit the crime at the arraignment? No, of course not. You're simply, all the judge wants to hear is whether you are accepting the charge against you, and then at that point, you can move on to sentencing or whatnot. But in the vast majority of cases, people enter a plea of not guilty. Now, the case does not end there. This is just the beginning. And this is the beginning of the beginning. I'm going to explain that in a little bit. But anyway, all the arraignment is to accept your plea. And then later on, if you can strike a deal with the prosecutor that you really, really like and minimizes some of the really horrible potential repercussions of getting convicted at trial, you strike some sort of a negotiation with the prosecutor, or your lawyer does that, you can change your plea later. You can change it to you can change it to no contest, nolo contendere, so on and so forth. Anyway, let's move on with the arraignment because, like I said, that's the firing shot. That's the first court appearance. It's a very important court appearance. I don't want to minimize it. And the reason for that is It really sets the stage for what's going to happen next, sets the tone. If the crime is severe, or the prosecutor is in the midst of filing more charges than what are in the complaint against you, they can ask the court to impose or raise bail. Now, that's a very dangerous proposition potentially, because then what that means is you have to you go into custody if the judge decides to do that, to impose or to raise bail. Even if you have money to bail out after that happens, you at least have to get processed, put into custody, and then your bail agent that you contract can get you out. I'm not going to go too much into bail issues, but you should probably, at a felony an arraignment for a felony case, you should probably have a bail agent there, because the likelihood of you getting remanded, that's what it's called, getting into custody, remanded into custody, is significant in many cases, or in many on many occasions. So if you don't want to stay locked up for the duration of your case, you may want to get that going right away. You may ask the court for release, OR release, meaning own recognizance release. If the case is severe, you're going to have a tough time. If the allegation is severe, you're going to have a tough time convincing the judge to do that. And part of that is for purposes of setting bail, the charges are deemed or considered to be true. So that's very tough to challenge. Generally speaking, whether or not to impose bail, there are other criteria, but the main one is whether or not you're a flight risk. In other words, are you going to get out of Dodge, go hide out somewhere? Is there a risk of that happening? And if so, the court may feel more comfortable tethering you to the court by virtue of bail. Okay, let's move on. And I'm not going to get into bail hearings and all that. This is just an overview of the process. So here's what happens next. So supposing all that happens, you enter a plea of not guilty and all that. If you have an attorney, the prosecutor is going to hand your attorney what's called a discovery, so the police reports and pictures of the crime scene and all this and that. Now, if it's given to you, it's got to be redacted, because you cannot. It's illegal for you. Obviously, the prosecutor doesn't want you to be contacting witnesses and harassing them or whatever, so it has to be redacted. You cannot have unredacted witness information in the discovery or the police report. If your lawyer has that, he also has to redact the witness information before he gives you a copy. Not going to get too much into the details of that because I want to move on. Anyway, your case will generally be placed on, and different courts call it different things. Some courts call it an early disposition proceeding, or EDP for short. It's also known as a pre-preliminary hearing or preliminary hearing setting. Now, the reason for that is that, legally speaking, you have 10 days from the date that you are charged with the crime at the arraignment. You have 10 days, or within that 10-day time frame, to have your preliminary hearing, which is like a mini trial. Not going to get into too much specifics about that in this particular video, because I want to give you more of an overview. Okay, so anyway, it gets put on the preliminary hearing setting calendar, and it gives you each time between the arraignment and the preliminary hearing, you'll have an opportunity to negotiate with the prosecutor. Again, this is all assuming that you've rejected court-appointed counsel, you don't have the money, and you figure you can just wing it. Don't recommend it, but you figure that you can defend yourself adequately on your own. Okay. Now you can waive time, because the Constitution says you have a right to speedy trial, and in most times it's not intelligent to just rush into the preliminary hearing. There are exceptions, okay? I'm not going to say there aren't, but generally speaking, defendants enter what's called a time waiver. So you're saying, hey, you know what? I know I have a right to speedy trial, but I'm going to waive that right, because I think it's in my best interest to do so. I need time to, maybe you want a private investigator to go out and talk to witnesses, muster up the defense in the case. You have to understand there's a lot at stake here. It's got to be a slow, methodical process if you have any chance of winning. I'm not going to delve too much into that concept, but I'm just going to move on here again. Arraignment, your case gets placed on the pre-preliminary hearing calendar, and then ultimately, if you figure that you want to move forward with the preliminary hearing, then you can at some point set the matter for preliminary hearing, and the court also is going to kind of force you to do that if the case starts. It's too many appearances. They want to see resolution for purposes of judicial economy. I mean, they have hundreds of thousands of cases every year. Okay, now here's what you need to understand about winning a felony case, and I want you to understand that the term win is a little bit subjective. It's not the same for everybody. In the criminal context, winning can mean simply avoiding jail and entering a plea deal with the prosecutor where you really cut your losses, so that also, of course, also can mean an acquittal, can mean a dismissal. Dismissals are far and few in between. Most of the time these cases get resolved by way of plea bargain. Some plea bargains are terrible for the defendant. I mean, they are what's called a Pyrrhic victory. So they load it up with so much responsibility and obligation that even if you don't go to jail, there's so many tripwires. You fail to, turn in community service, or fail to complete this or that class, and you can get remanded into custody. So what I mean by win is a plea bargain that's fair, or as fair as possible to you, where you're not so loaded up with obligations that you might as well take some custody time and avoid all that. But I'm not going to get too much into the specifics of that. What I want to tell you is that the EDP, the pre-preliminary hearing, or the preliminary hearing setting dates, are key for many reasons. First of all, the prosecutor is going to give you a deal. They're going to offer you something. And generally speaking, there are exceptions, but generally speaking, the deal that you're being offered is going to be as good as it gets. Meaning the offer is not going to get much better after the preliminary hearing is over, because it's a bargain. They're trading with you. They're saying, okay, we're not going to use all our resources against you, but in return for that, we want a pound of flesh, so to speak. So you give them, you enter a guilty plea to a particular charge, and maybe they dismiss some of the other ones, and you get a little bit of jail time or no jail time at all, or alternative sentencing. So whatever you're comfortable with, I would say you should deliberate. You should think carefully, consider it, take it to a lawyer, ask him what he thinks. If he's got to have the experience. Of course, you don't go to a personal injury attorney for something like this. You go to an experienced felony crimes defense attorney to see, get an opinion. Is it a good idea? You can make the decision after you've examined it carefully on your own or with an attorney, and accept it, and you're done. Okay? That's not how I go about it when I represent my clients. I actually, we build up a ton of leverage. You can do this too, by the way. For example, we use investigators. I like using investigators because we want to find out your side of the story. We can't do it by just saying, disagreeing with, well, the prosecutor, the police report is wrong. Well, there's a saying in the movie Training Day, you want to go to jail or you want to go home. It's not what you know, it's what you can prove. Prove it. And a lot of lawyers will say, well, it's not the burden of the defense attorney to prove it. Okay, well, listen, that's fine. That's a nice conceptually, but in real life, either you or if you're being represented by counsel, you want to really find and exploit the weaknesses of the prosecutor's case against you. As much as possible, private investigation is a tremendous tool because it can uncover a lot of bullshit. It can cut through For example, if the witness is lying and they're making later on they contradict themselves or they take back their initial allegation, I mean, that's important. That's key, because then you have bargaining power. Now suddenly the prosecutor understands that you're picking up momentum in your defense. You might win a trial. Is this something they're going to want to pursue? Is it a worthwhile investment of their resources to pursue a case where the facts aren't so clear anymore because your private investigator has found problems with the prosecutor's case? It's all important, very, very important to pick up that sort of leverage. You can do it early on too. You don't need to wait. You want to get that stuff going immediately, at or even before the arraignment if possible. Okay. Anyway, so let's suppose, so that first stage is called the pre-preliminary or preliminary hearing process. This is just the beginning of the case, because generally speaking, in California felony cases, your felony accusation against you is cut up into think of three columns or three phases. The first phase is between the arraignment and the preliminary hearing. Now the second phase, let's say the prosecutor gives you a deal that you hate, you don't like it, they want you to go to prison, or you principally feel that you should get a better deal. You have to make that decision. You can reject the deal and just keep going. Go to the preliminary hearing. It's hard for me to advise you how to handle a preliminary hearing, to be quite honest with you, because that does require very experienced legal work, cross-examination. You're getting into evidence rules and all that. Now, you can actually wait. You don't have to have the preliminary hearing. You can waive it. I wouldn't recommend it. Sometimes it is recommendable. But suppose you handle it on your own pretty good. You ask very incisive, probing questions of the investigating officer at the preliminary hearing, and you're able to at least tatter their credibility enough that once you're after the preliminary hearing, now you're in the pre-trial phase, and then the last phase is trial. Most cases don't ever even go to the third phase, though. I would say most cases resolve either at the preliminary hearing or the pretrial stage. The pretrial stage it presents a lot of great opportunities for really putting some damage into the prosecutor's case. You can file motions. You can file a motion. It's a Penal Code 997, and this is a motion to dismiss. I'm going off memory here, so excuse me if I don't have that Penal Code section accurate or perfect right now, but generally speaking, this is a motion to dismiss. Okay, and now you're going to have to only argue what's called the four corners of the preliminary hearing transcript. You're going to get the transcript of the preliminary hearing, and then you're going to show the judge, listen, you should have dismissed the case because of all these. Specifically, let me talk to you about this. You want to go to the elements of the case. In other words, you want to tell that when you're filing or drafting the motion to dismiss per Penal Code 997, your main argument is going to be that the government failed to meet the elements of the case against. So, for example, if it's like a felony driving under the influence case, you have to be driving, you have to be under the influence of some intoxicating substance. So, for example, if they couldn't prove that you were driving, see, that's one element of the offense. It's in the title, for God's sake. You can certainly argue that. You want to base it in reality, though. You don't just want to say, well, I wasn't driving under the influence. That's not going to get you anywhere. You want to what I always tell people, you want to challenge the prosecutor's case, the weaknesses. So one of the weaknesses is if they can't prove that you were even driving. Let's say you were asleep behind the wheel of your car. Now they can argue that, well, common sense dictates, or they felt the hood of your car, you were recently driving. Okay, you can have that back and forth. But again, you want to attack the elements, and if you're able to do that, if the judge believes it, they grant it, you can get the case dismissed. The only problem is the prosecutor can refile, but I'm not going to get into that. I'm just giving you some ideas here about potentially winning your case on your own. And also, as time goes on, let's say you have an investigator working for you, somebody that you can, like I've said in other occasions, you can find private investigators that don't charge too much. Maybe they charge by the hour, but they don't need to take up too many hours. Maybe they're still making the rounds with the witnesses, and they're able to get more contradictory statements from witnesses or any other sort of evidence that helps prove that you're not guilty. That's just another opportunity. So now, I'm not going to get into winning the case at trial. I have respect for people who represent themselves in court if they know what they're doing. Trial is another discussion completely. Trial can go haywire for you in 5 minutes if you don't know what you're doing, and that includes if you don't know the rules if you're not an attorney. Let's be blunt here. But even if you are a very self-confident and competent self-represented person, you got to know the rules of evidence, and the rules of evidence are legion. I mean, you have to know rules about hearsay and relevancy, and I mean, people go to law school for 3 to 4 years, and they apprentice with other attorneys and all just to learn all that stuff. So it's immensely complicated. I am talking about winning a case early on through early disposition proceeding, negotiating with the prosecutor, and or a situation where you're able to effectively argue for a dismissal after the preliminary hearing. I'm going to end with one other idea for you here, and then I'm going to wrap it up. This video is getting a little long. Something else you can file, another type of motion, is a Penal Code 1538.5. This is a motion to exclude certain evidence on the basis that it violates the Fourth Amendment. For example, if it's a drug possession case, and the police entered without a warrant, or they had a defective warrant, or they searched your automobile and they didn't have any probable cause to do it, you can actually, this is the great thing about this type of motion, is you're not even arguing your innocence or guilt. Forget that. You're arguing whether the prosecutor can even use the evidence they have against you, even if you're 100% guilty. But if the police, if law enforcement did not lawfully gather that evidence, or if they violated your Fourth Amendment rights in the process of gathering that evidence, and you make that case to the judge, even if you're guilty as hell, if you make that case to the judge and he grants your motion, you're done. Case is done. And the reason for that is because the prosecutor, even if they know that you're guilty, they have overwhelming evidence, the court is tying their hands. They can't use that evidence, no matter how overwhelming. Now, if they can prove it in other ways, then a 1538.5 motion to suppress, that's what it's called, motion to suppress evidence, it'll make a dent. It's not going to get rid of the case completely. But let me tell you, every dent you can possibly put into the prosecutor's case is just going to get you that much closer to getting the result that you want, which is absolutely minimal jail time, if anything at all, or diversion or something where you walk away as unscathed as possible. Now, if you represent yourself, the likelihood of that happening is, well, I'll put it to this way, it's very challenging to do that, but it's not impossible. And I hope you've taken this information and consider it. This is not legal advice. Nothing replaces a face-to-face conversation with, for example, myself. I'm an experienced felony crimes defense lawyer. I've filed these motions time and again, and with much success. So that doesn't replace that, but it's something to think about. Thanks for watching.